Awesome, Nick. So first question we have for today. So I'm going to paraphrase the question, but basically it's an agent that has a question regarding a tenant and a tenant moving out of the property earlier than anticipated. This was, I don't think the dates make much of a difference here, but basically it seems like they moved out sooner than they were supposed to move out, prior to the expiration of the lease. Now, there was an inspection that was carried out by the landlord with the tenant. So the inspection was indeed carried out, but strictly speaking, it was not within 3 days prior to the expiration of the lease. And the tenant is now arguing that by virtue of that fact, by virtue of it not being exactly 3 days prior to the expiration, it falls foul of the Rental Housing Act, and the landlord now does not have any right to claim anything from the tenants with respect to damages. So I think over here, maybe just clarify expiration as an example, just clarify where the 3-day rule comes from, and obviously, where possible abuses might arise, such as this one.
Okay, perfect. So, in terms of our Rental Housing Act, okay, there is a section within the Act, which is Section 5. It deals with provisions pertaining to lease agreements. And what's important with regards to provision Section 5 is that subsection 3 of that section are terms which are deemed to be part of a lease agreement. Okay, so it's certain provisions that are deemed to be part of the lease agreement, and you need to comply with these particular provisions. You can't contract out of them. Okay, now in terms of subsection F of those particular provisions, okay, it is a provision that relates to joint inspection of the property when a tenant is moving out of a particular property. And what it requires is that the tenant and the landlord find a mutually convenient time to inspect the property. And what the section says is within a period of 3 days of the expiration, okay, of the lease agreement. Now, I have my own views about this particular section. I've always felt that it's a little bit difficult because inspecting a premises prior to someone vacating a premises is challenging. All right. If your tenant still has all of their furniture and things inside the premises because it's still 3 days before the expiration of the lease, so they can still occupy that space, this makes inspecting a premises potentially very, very difficult, and almost certainly in certain circumstances impossible, because how are you as the landlord supposed to gauge what damage has occurred if there are couches and fridges and carpets in the way? But regardless, that is what the legislation requires us to do. So 3 days within a 3-day period prior to the expiration of the lease agreement, there needs to be a joint inspection that the parties have at a mutually convenient time. Now, why this is important is this subsection goes on to say at subsection J that a failure by a landlord to inspect the tenant, the premises with the tenant, as contemplated in that section, will be deemed to be an acknowledgement by the landlord that the property is in good order. Okay, and then the landlord will be have to pay back the deposit and interest to the tenant in the circumstances as a result of this deeming provision that the property is in good order. So you can see that this is a difficult part of legislation, and one that I've fundamentally had struggles with in the past. But notwithstanding, if we bring it over to our question that we've had today, so we've got a tenant. They say that there was an inspection done by the tenant and the landlord. It was earlier than the expiration of the lease agreement because the tenant was moving out early. And what the tenants has done is they've now come and said, no, you're falling foul of the legislation because you haven't done the inspection within the 3-day period of the expiry of the lease agreement. And so they are submitting that the deposit and interest must be paid back to them without any deductions from the landlord, because he would have deemed the property to be in order. But I think from a reading of the particular circumstance, I don't think it's going to be that simple. The first thing is, yes, we must interpret legislation as it's written, and applied as the legislature has provided legislation. But please remember, legislation doesn't exist in a vacuum, and actual facts and actual circumstances must be taken into account. When we go and argue in front of a court, we can never just sit there and go, well, this is what the legislation says. Background counts. Okay. And in this particular circumstance, we've got a landlord, a tenant, and the tenant is moving out earlier. The landlord did the inspection on the day that the tenant is moving out. So the tenant is relying on the expiration date that's set out within the lease agreement when it was signed. But the fact that the tenant is moving out on that particular day and handing back the keys to the landlord on that particular day, and they did the inspection on that particular day, in my view, would mean that the expiration date has been moved forward to that point. Okay, it was intended to be the end of the month, but the fact that the tenant is now moving out earlier and handing back the means of access to the property means that that expiration date has moved forward. Okay, and if we treat the expiration date as moved forward and the tenant and the landlord did the inspection on that particular day, they've done it on the expiration date of the lease agreement, and that would bring them in line with the legislation. That would be the first thing. But also, again, we have to follow legislation, but we need to be practical about these things. If the parties had agreed to an inspection date, which doesn't fall strictly within that legislation, I am still positive that there could be some scope to say in front of a tribunal, in front of a judge, what the parties did was they found a mutual convenient date. Does it exactly match up with the legislation? No, it doesn't. But the parties agreed to some other date because of their personal circumstances. It's very unlikely that a court is simply going to go, no, it's not within 3 days, and we're going to ignore the fact that this is your mutually convenient time that was available to both of you, and you must be deemed. Courts are there to apply legislation strictly, but also to take account of the factors and the relevant circumstances that people have to go through. So I think the landlord would be fine in this circumstance because the expiration would move forward, in my view, to the date that they actually did the inspection. But in any event, such a strict interpretation, I think, it wouldn't be upheld by a court because they would take account of the factual circumstances in this particular case.
Cool.
All right.
Cool.